Our next speaker is going to be Thomas Meiklejohn, and after that will be Michael Hunter. So good morning, good afternoon.
Good afternoon. Thank you, Chairman Lieben, distinguished members of the board. My name is Thomas Meiklejohn. I'm with the law firm of Livingston, Adler, Pulda, Meiklejohn, and Kelly in Hartford, Connecticut. I've appeared on behalf of unions in representation cases in the Boston office, Hartford, Brooklyn, and Manhattan. I also worked as a field attorney and a supervising attorney for the board in Hartford and in Philadelphia before that. I come here to speak. I'd like to speak. Well, first, I guess I'd like to resist the temptation to, I may not, but I'll try to resist the temptation to get into a debate with the previous speaker, but I probably won't resist it. I was going to try to speak from the perspective of a practitioner. I appear in front of a number of different court and administrative bodies. A practitioner who believes that litigation should be a process for resolving the issues that are before the body to be decided, and not a process for achieving other ends. I'm not, we all have an idea of what ends we think the parties sometimes seek to achieve in representation case hearings. But with all respect to Mr. Kramer, clarifying who the parties can use as their advocates in a campaign is not the function of a representation case hearing. The function of a representation case hearing is to determine whether the unit proposed by the union or the petitioners is an appropriate unit, and who would be eligible to vote as members of that bargaining unit. And frankly, as a practical matter, the employer has tremendous access to information about who, what authority alleged potential supervisors might exercise. And the union is often shooting in the dark and taking a big risk in allowing potential supervisors to become their advocates in a campaign. But the way to deal with that is to not have a hearing on an issue that's not necessary to resolve the core question of whether there is whether the petition for employees have a community of interest. So I guess my first point is just that I don't see anything particularly radical in limiting the issues to ones that are necessary to deciding the questions before the board or before the regional director. And I don't see anything particularly radical at all in requiring the parties to clearly state a position beyond, this particular unit is not appropriate. In my experience in Hartford, and I will say, throw in my 2 cents worth for the Hartford regional office, they do an excellent job in most cases of putting the employer's attorney in a position where they have to state what their position is if there's going to be a hearing. And in fact, most of the management attorneys that I deal with, generally speaking, do state a clear position on what the bargaining unit is. But there are those exceptions. There are the employers who come in and describe a unit using job descriptions and job titles that the employees have never heard of. And if the employees and the union don't have access to the names of the people, then we don't know who they're really litigating about. We can't figure out. I do remember clearly one hearing where the employer litigated job classifications for 2 days. And then on the third day came in and said, oops, well, that's really not the job titles that we use in this particular factory. It was a factory. This is a while ago, obviously. The information that the board is asking is the kind of information that I think in any kind of litigation you expect to have available to you before the hearing starts. And it enables opposing counsel to figure out what the issues are and what's relevant, and it allows the hearing officer to determine what evidence does and does not need to be admitted. So that leaves me 45 seconds to talk, to do my prepared remarks. So I will just mention one case that I had in the past year involving a company called Autumn Transport. We received what's still called the Excelsior list, had names and addresses. These were the names and addresses that the company used to communicate, or that the company had in its records. And dozens of those addresses were incorrect because the employer didn't use addresses to communicate with its employees. Employees were required to provide current, accurate telephone numbers where they could be reached, but the addresses that the union got were by and large pretty, almost useless. So simple changes like requiring names and addresses will enable the unions to communicate with the voters in the same fashion that the employers are already communicating with their employees. Thank you.
I just have a couple of quick questions. First, my guess is that, I think as you know, that the bulk of our cases proceed to election on the basis of a voluntary agreement between the parties. I'm wondering if you have any view as to whether or not the proposed rules would decrease the likelihood of the parties entering into voluntary agreements.
I did give that some thought when they first came out. I had some hesitancy about it. But I think that by requiring the parties to clarify their positions and take their positions quickly, that in the long run, there may be an adjustment period, but I think in the long run, it will result in an improvement in that regard. In my view, it's the regions and the regional personnel who are most effective in getting those agreements. It requires cooperation from the parties. And I think that if you view this collection of rules as a whole, that it provides the regional personnel with additional tools to use in bringing the parties to an agreement.
And just if I can, to follow up on one other thing, is my understanding of your position correct that Section 9C of the Act doesn't statutorily require a hearing in the event the parties raise issues with respect to the supervisory status of named individuals?
9C requires a hearing when there's to determine whether there is a question concerning representation. And the precise parameters of the bargaining unit are not necessary to be determined in order to address the 9C question.
Anything further?
With regard to this case, this Autumn Transport, where you got a lot of information that was not up to date, the proposed rules are asking for additional information in the Excelsior list. How do you think that would impact on scenarios like you described in Autumn Transport?
Well, what I'm saying is that the employer had, in this case, it was cell phone or telephone numbers that were critical. They had certain information that they used to communicate. In a particular case, you may not know whether the employer, communicates by email or telephone or whatever, but in this case, they would have had to provide telephones. That was the information that the employer used to communicate with the employees. And it, really just, providing providing addresses, it's what the rule required, it's all they had to do, but it was really hiding information from the union. It was the telephone numbers in that case that would have been useful. In many other circumstances, I think in the modern workplace, it would be email addresses.
Thank you.
Thank you very much. We appreciate your contribution.